Good evenings. My name is Lewis Powell, and it's my pleasure to be with you once again on behalf of the Cook County Bar Association, the world's oldest, we like saying that, the world's oldest African American bar association in the world, technically formed in 1914 in the city of Chicago. And you know, ladies and gentlemen, we have a celebrity guest. We have one of the most dynamic former presidents that the Cook County Bar Association has ever had. And you know, Celeste, you know, before you became president, you worked very hard on behalf of the bar. And a lot of people, including me, were very happy that you got an opportunity to be the head of this great organization. And you did something with it, because you know your year was all year is a great year, but you had an exceptional bar year, and I think was that 2 years ago. Time is flying,
yes.
And it was just a marvelous year. As a matter of fact, I think that was the centennial year of the bar.
Yes, it was.
You know, so, former President Mays had the honor to be the president of the Cook County Bar Association when we celebrated our 100th anniversary, and it was just a marvelous year. A lot of programs, a lot of information getting out to communities, so forth and so on. We just had a good time, as we say in the business. But ladies and gentlemen, we really want you. It's no fun. You know, it is fun. I'll keep talking to Celeste, Attorney Mays, all day. But we want Attorney Mays to get out some information to you. We want you all to call us, because you know the topic of discussion today is child support, and we know that's an issue that affects a lot of individuals. The phone number that you can call is 312-738-1060. 312-738-1060. We want you to call in. Now call in with questions that are relevant to the topic. And if it's relevant to the topic, to the extent Attorney Mays will answer your questions. Okay, Attorney Mays, I understand there's been a change in the law.
Yes, well, it hasn't come into effect yet. It won't be coming into effect until next summer. But right now, child support is based on the payor's income. Depending on how many children there are. There can be, there's 20% for one child, and this is net income. 25% for 2 children, 32% for 3 children, and it goes up depending on how many children you have. That's the way it's been for quite a long time. But next July, the law is going to be changing, and it's going to be, in my opinion, more fair, because it's going to be more of income sharing, whereas right now they only look at one person's income when it comes to determining child support. But the new law, they're going to be looking at both parties' income.
I'm going to stop you from time to time, President Mays, if you don't mind. Now, what is this income sharing? Because, you know, this is not my area, but I do know, I just thought it was really based upon, 9 times out of 10, it's the man.
Right.
Okay,
right.
the male,
and that's exactly who it
right.
is.
Right,
yes.
usually it's to focus on how much the male is making. But explain this income sharing.
Well, basically, let me just tell people how it worked in the past. Like, for an example, I had a case where it was 2 very successful individuals. Husband made about $100,000 a year. Wife made $220,000 a year. In this particular case, it was 2 children. So the court took 28% of husband's net income for child support. They didn't take into consideration that wife made more than twice of what husband made. And so therefore, a lot of people think that's unfair, because they're like, you know, my spouse makes more money than I do, whether it's, you know, the husband or the wife or etc. But now with income sharing, they're going to be actually looking at what both parties make. And it basically becomes much more fair. The law is not finalized yet, because it does not come into effect until next July. But basically, they're going to be looking at the cost of raising a child, and then they're going to look at what spouse A makes, spouse B makes, or parent B makes, and then they are going to decide how much each party contributes to raising that child. And so therefore, if one has to contribute more, then it'd be money that would be paid to the other spouse. So it makes it fair in that they're looking at what both parties make, which is a lot of my clients, they've never understood why they only looked at what the payor basically makes. And I think
Mays,
that
forgive me interrupting you. Now, what is the majority of your if it's okay? What is the majority of your client base in terms of male, female in the area of child support?
Well, my client base is both male and female.
I knew you were going to say that.
But
what's the
it's true.
percentage?
It absolutely is true. It is. I've never really sat down and actually did the percentage. But I will say this: vast majority of the cases, vast majority by far, under the current law, it is the man who is paying the child support,
regardless of how much.
Regardless of how much the woman makes. Yes.
Former President Mays. Soror, aka, what took them so long to come to this new revolution that it should be like equal distribution?
I don't know. I don't know what the delay was, because of the fact that there are numerous states that have been doing this for years. I mean, for years, and it is a more fair formula, so that I think that the court should look at what both parties are making in determining it.
Well, it seems fair to me. In terms of what expenses does child support cover?
Well, child support basically is the general expenses of the child. It's supposed to cover housing and food and, clothing and things like that. However, there are a lot of things that child support does not cover. It does not cover private school tuition. Does not cover extracurricular activities. It does not cover uninsured medical expenses, things like that. And child care, it does not cover child care. So therefore, under the current statute, a court can order a party to contribute above and beyond child support to those expenses. Private school is it's within the discretion of the court, because it depends on whether the child is already in the private school. Courts don't like to move a child out of a school that a child has become accustomed to. But extracurricular activities, child care, uninsured medical expenses, those are explicitly outlined in the statute, that the court can order a party to contribute to those above and beyond child support.
Counsel, I think we have a call.
Okay.
Caller, are you there?
Yes, just listening to y'all's show. I've been listening a little bit more. It's very curious. Now, if a man is paying child support, and a very large amount of child support, also supporting the child with insurance for the health arena, in that health area, and also paying school tuitions, so would that make the man be able to use that for deduction on his income tax, or do the wife will make the deductions? How would that go?
Well, I always tell people whenever people ask me about deductions on tax returns, I always tell them I'm a lawyer, I'm not an accountant, and to always consult your accountant to determine what you can and what you cannot deduct on a tax return, because a lot of it depends on whether or not you are allowed to deduct the child. And I always, whenever I have a case and I represent the man, I always ask the court and file a motion to ask the court to alternate deducting the child as a dependency exemption, because if you can't deduct the child, you can't deduct like child care expenses and things like that on your tax returns. So if you are paying child support, it is worth going to court and asking a court to order, that you would be able to deduct the child, every other year, or depending on what mom's income is, if it's extremely low, that you be allowed to deduct the child every year. I've definitely have had that where the payor spouse or parent is the one that had exclusive rights to deduct the child. And it's not uncommon at all when you have more than one child, when you have two or more children, that one side can deduct at least one child.
Well, what if, Attorney Mays, what if you have two? If the gentleman's paying child support for two, can he still deduct for the two?
Well, you can if the judge orders that, but it's very common that the judge would end up giving one child to each of the parents. That's very common.
Okay. How does someone go about getting child support?
Well, you don't have to have a private attorney to do it, even though, of course, as a private attorney, I would encourage everyone to do that. But if you do not have the funds to give a private attorney, or even if you do have it, you can obtain services through the Illinois Healthcare and Family Services. It's a free service, and it is available to everyone who is a parent that is in the possession of the child to assist you in getting child support. And actually, the state's attorney's office in Cook County is the one that's actually assisting you in court to get child support. When people call me and seeking just child support, I always, as a courtesy, tell them that that is a free service. Now, the downside is that, of course, is, you know, when you're dealing with the government, they're dealing with thousands and thousands of cases. Your case does not move as quickly as it would with a private attorney. But if you don't have the funds and you have time to wait, then you may want to go through that route. Also, the Cook County Bar Association, we have a lawyer referral service. And so if you are looking for a private attorney to assist you in getting child support, you can definitely call the Bar Association Lawyer Referral Service.
And that number is 312-630-1157. You know, former President Mays, you know, you're getting free information from this great attorney. We're going to come back. Caller, are you there? Okay, someone is calling.
Okay.
Caller, are you there?
Hi. Hello, I'm here.
Thank you. Your question,
so
please.
I just tuned in just a bit ago, and I have my sister. She's currently going through a separation with the father of her child, and they went to court, and there was, I guess, a temporary order that tells them how much time each person can spend with the child. But now the next thing that they're asking about is child support. My sister's seeking child support. And the father keeps on extending or asking for an extension of the court date. Do you know why or do you have any ideas of why the judge would continue to allow an extension? It's been about 2 extensions already.
Well, there are a lot of factors that can come into play regarding extending court dates. And I don't know a lot about the case, so I'll just give you some examples. Whenever you file a motion for child support, for temporary support, both parties have to complete what's called a financial affidavit. It's a very long form that requires both sides to disclose all of their income and their assets. Under the local rules here in Cook County, you're also required to provide your 2 most recent years of tax returns. You're also required to provide recent pay stubs. So the court has to give time for both parties to exchange those documents. If you are the one that is seeking support, if you have not done it, the court generally is not going to set the case for a hearing. So, you know, both sides have to do it, but especially the person who is seeking support has to fill out those documents. If a motion has been filed, you always give the other time to respond to the motion. And responding is a written response where they actually go through the motion and they admit or deny each of the allegations that are in there. They have an opportunity to present any affirmative defenses, which basically would state why they should not have to pay child support. So, and also too, it depends on the court's calendar. Some judges, their calendars are very backed up. And it takes months, unfortunately, to actually get to a hearing date. And a lot of judges will not even set a hearing date until both parties have complied with the local rules, the party has responded, and then they will actually set a hearing date. So unfortunately, it doesn't move as quickly as everyone would like it to. But the good thing is that under the new statute, when you have child support, it is not an evidentiary hearing, which basically means that you're not giving testimony and all of that. The judge can basically review the financial affidavits, review the documents that are before him or her, like the pay stubs, etc., and without taking testimony can actually enter an order for child support. So, the downside is that you have to give time for all of those things to be done, but the upside is that once a hearing date is set, it can be very quick because the judge is not going to be, hearing testimony.
In terms of child support, now I got it that it may be a backlog in terms of the actual hearing date, but is it retroactive?
Yes, and that's important for everyone to understand. You definitely can ask the court to make it retroactive to the date that you file your petition for child support. Because the courts understand that it could be months before you actually have a hearing date. And it would be very unfair that because you couldn't get a hearing date until 4 or 5 months out, that you miss out on those 4 or 5 months of child support. Now, retroactive is in the discretion of the court, but generally they do award retroactive child support to the date of filing.
That's good. That's common sense.
And also, too, you should also know that in parentage cases, where the parties are not married, when you file a case and once he is served, you also have the right to ask for child support before you filed your case. There are a whole lot of different factors the court would look at as to whether or not to give child support back to the date of birth of the child. But you also can ask for that. So I always tell people, ask for everything. Let the judge make the decision as to whether or not you get it, but definitely ask for the retroactive child support.
Attorney Mays, can adoption affect child support?
Well, yes, it can. Let's say, for an example, you have a mom and a dad. Dad gives up his rights as the father, and another man comes in and actually adopts the child. Then that father who gave up his rights and is no longer responsible for child support for that child. That child support would have to be paid by that adoptive father.
I want to make sure I understand that. So are you saying, counsel, that the divorce happens, the woman marries another man. Now, if the man chooses to adopt the child, if that happens, then the original, I mean not the original, but the divorced spouse is no longer responsible for child support.
Well, you know, in cases like that, that almost never happens. I've never had a case. I had a case where a man was so angry with the wife that he was willing to give up his child, you know, his rights to his child. And of course, after he settled down, all of that went away. I mean, generally that does not happen in divorce cases. I mean, people they've already established a relationship with their child and they're not going to give that up. So that rarely, I've never had a situation where someone after they got a divorce actually gave up their rights and allowed another person to come in and adopt the child.
Okay. How about guardianship?
Well, guardianship, child support can also come into play. For an example, let's say that mom has deceased, is dead, dad is still alive. The guardianship is awarded to the grandmother. Grandmother can ask the court to order dad to continue to support the child.
Visitation, can that affect child support?
Well, visitation is now called allocation of parenting time. The statute that came into effect recently basically abolished the term custody and the term visitation. It is now allocation of parental responsibilities, formerly known as custody, and allocation of parenting time, which is basically formerly known as visitation. The courts, then there has been case law where, you know, you're not supposed to, you know, not pay child support if you're not getting visitation, you know, or vice versa. You can't do that. If you're not getting, you know, your visitation, you still have to pay your child support. You should immediately go into court and on a motion to order the other side to give you visitation. If you're giving visitation and you're not getting child support, then you need to go into court and ask the court to order the other side to pay for child support. So just because you're not seeing your child, you're still obligated to pay child support if an order is in existence, and just because you are, you know, and basically vice versa too.
I want to make sure I understand it. What about for the gentleman, if he is not paying his child support the way he's supposed to, can his visitation rights be affected?
No, he still gets to see his child. But not paying your child support is a very, very serious issue, because you can actually go to jail if there is an existing child support order and you are not paying the child support. So I always tell people, if you have an order, pay the child support. If anything changes, your job changes and you're making less money, you lose your job, you get laid off, immediately file a motion to modify the child support, because that's a substantial change of circumstance. If circumstances change, you absolutely can go into court and ask for a modification. Don't sit on that, because your retroactive relief is only to the date of filing, meaning that, let's say you've been laid off and you've been laid off for 6 months, you didn't go into court and ask for your child support to be modified, and then all of a sudden you decide you're going to go in and ask for the court to be modified. Those 6 months that you were not working and not making any money but did not file a motion for modification, you still owe that child support, because that order was still in effect and it was not modified.
Okay. When does child support stop?
Child support basically stops when the child turns 18 or when the child graduates from high school, but not beyond the child's 19th birthday. So if you have a child that is, in high school and has turned 18 years old, your child support should go ahead and terminate when the child graduates. Now, after the child graduates from high school, under Illinois law, you can be ordered to pay college expenses. And college expenses, can be a little expensive. So even though you're not paying the child support, either party can go into court and ask the other party to contribute to college expenses. And the college expense statute is very, very broad, because college expenses can cover not only room and board and tuition, but it can cover registration fees, it can cover transportation costs. I mean, it's a lot. So even though your child has graduated from high school, you still can be on the hook for supporting the child for another 4 years.
In terms of the college, because we want to encourage young people to go to college.
Absolutely.
Is there a limit in terms of how far the person that's paying child support is obligated, say, for college as well as post grad?
Well, they have now changed the statute in that they've actually put in there that you're supposed to look at what it costs to go to, I believe it is University of Illinois in Urbana, I believe. It's one of the state schools, and that's kind of like your benchmark that the court is supposed to. Now, the child may not go there. The child could be going to Harvard or a state school in another state. But that is what the court is supposed to look at to determine how much the other party who's not petitioning the court has to pay. So even though, the out-of-state tuition might be $40,000 a year, if it's only $20,000 in Illinois with that school that's under the statute, that is what the court is supposed to basically look at.
Attorney Mays, I know this may happen from time to time. What if the gentleman, as time goes by, is able to prove that the youngster who he's been paying child support faithfully is not his? What are the ramifications? Can he go after his former spouse for that?
Well, I'm gonna tell you that one's kind of long and kind of complicated. I know we only have a few minutes left, basically on that one. But let's say, for an example, let's do the parentage one so that it's a little easier. A lot of people want to know if they, if they thought they were the father, and she was told that it was father, and they had been paying child support and everything like that. Whenever you go into court on a parentage case, with people that are not married, you are entitled to have a DNA test. And I always encourage people, get the DNA test. You need to know whether or not you really are the biological father of that child, because you will be on the hook for paying child support until that child is 18 and then 4 years or 5 years of college. So I always encourage that so that before that child support order is entered, whether or not you are actually the father of the child. So I would strongly encourage everybody to get that test to make sure that they are actually the biological father. And it doesn't come back saying, yes, you are the biological father. It comes back with a percentage. So if you're 99.9999% the father, chances are the father, then chances are you're really the father.
Attorney Mays, why is it in the community that there's so many gentlemen that are able to get away by not paying their child support?
Well, first of all, you have to go to court. You have to, first of all, have an actual court order. A man might be paying child support and giving mom, $50 a week or $500 a week in child support. But if there is not an order entered, he's not obligated to do that. Now, it's okay for people to work out how much support, and avoid court. That is perfectly fine to do that. If you are a man, always document whatever it is you're giving mom. And what you document with it is you're paying mom either a check or you're paying mom with a money order, something where you have a receipt to show that you are actually paying child support.
But you know what I really just can't fathom is why there's so many people out there that are just not paying.
Well, you have to take them to court and you have to get a court order. And if they still do not pay, when a court order, you can file what's called a petition for root to show cause to ask that the parent be held in contempt of court. And like I said earlier, jail time can be an option, is an option that the court can order. And put the person in jail, and their bail is actually the amount of money that they actually owe, or an amount that the court determines is reasonable and fair.
We have about 30 seconds. You know, Celeste, it's been a pleasure having you.
Thank you.
As you know, with the Cook County Bar Association, we pride ourselves in giving information folks that can use, and it's just a delight just to have you, because you've really worked hard on behalf of this Bar Association.
Thank
I'm
you.
just glad to see you get your time in the limelight.
Thank you.
We'll be back the same time next week. God bless you.
Thank you.